One is it is very cultural as well. How to address, or put it the other way, a good argument in a particular jurisdiction may not necessarily be a good argument in another jurisdiction. Sometimes depends on the way things are expressed and so on. And apart from the essential, the basis, of course, you have the point to make, you know your arguments, you know why you're making, you know your weakness, you know your strength, and preparing an argument, the best way to start is always ask yourself what is your weakest point, because your weakest point will be the strongest point of the other side, and no matter how many good points you have, you lose on one weak point, you lose a case. And some judges tend to focus more on the technical side, other people may focus more on things, and there are cases which I think if I can't get through the message in the first half hour, I'm doomed on that case, or I need to convince the court to see the case from a particular perspective, and I have to do it in the first hour. If I can't get it there, I will be in great trouble, no matter what good argument I will have. Now, so I think in public law case, this is probably more important, but even in private law case, sometimes the first half an hour or half hour, and so how you open the case, how to define the case for the court is extremely important. Having a good point is one thing, how to deliver it and deliver it effectively is quite another. And there are the time pressure there, and even more so with oral advocacy, because you are always given a period of time sufficient. And even in court, the time is not unlimited. In mooting, we give you 20 minutes. In real life, you got more than that. But then in even that, there's a limit there. And I once before a very senior judge, and the first thing he said that you have to finish your arguments by 12 o'clock. If you can't finish, sit down and shut up. Very hostile, and before I say anything. So how to deal with that? And sometimes oral argument has to deal with personality as well, and because you are addressing a person, and different persons will have different approach and so on. You know your person sometimes helps. The best way is still to do it, and sometimes watch yourself, video yourself, and then watch yourself how you do. A lot of people do not recognize how they speak. You can hear your voice, but you can't see your facial expression. You can't see some of your minor things about how your hands is walking, your body language, etc. And it helps with this. And you have to spend time on that, and spend time to think about the effectiveness. Or argument is not, you are not there just to make the argument for the sake of argument. You are trying to persuade, to convince people. So there's always a sort of interactive element there. You have to follow that person's reactions, why he's asking this question, what is troubling him, so that I can address his concern. One last thing I tell students is that you go to court, see some great advocates. What you've seen is probably 2 or 3 hours of work. What you have not seen is the 30 or 50 hours of work behind that. And the more natural they appear, the more preparation it is. And Winston Churchill is, there's no such thing as natural. Natural is practice, and practice until you reach the point that you become natural.